everyone. Welcome to the program. Now, we begin right now, of course, with a meeting. We hear the president is meeting with security chief at this moment before his trip to the United Kingdom. We'll bring you more on that story about the meeting with security chiefs. But also, he will be departing Abuja today, January the 17th, for London. And that's to participate in the inaugural UK-Africa Investment Summit holding Monday, January 20, 2020. According to organisers, the event hosted by British Prime Minister Boris Johnson is expected to bring together African leaders, international business, chief executives and heads of international organisations. Issues of sustainable finance, infrastructure, trade and investment, future African growth sectors, clean energy and climate are expected to dominate discussions at the summit. While in the UK, President Buhari is expected to meet with the head of the Commonwealth, Prince Charles, in Glasgow, Scotland, as well as Prime Minister Boris Johnson. He's expected back in Abuja next Thursday. And to other legal stories, and this is starting from outside of the country, where some eagle eyes are monitoring money stolen from the country by a former governor. A British prosecutor is reported to have launched a fresh attempt to confiscate funds stolen from Nigeria by a former governor of Delta State, Mr. Ibezim-Ohaeri. Now, he had pleaded guilty at London's Southwark Crown Court in 2012 to 10 counts of fraud and money laundering and was jailed for 13 years. He was, however, released from jail in December 2016, after which he returned to Nigeria, having served half of his sentence in pre- and post-trial detention. Now, according to Reuters, prosecution counsel Jonathan Kinnear started the process at Southwark and began listing assets that Britain seeks to confiscate from Mr. Buhari and return to Nigeria. Efforts made in 2013 by the UK to confiscate the funds were not successful due to unresolved legal disputes after weeks of hearings. The total value of the known proceeds of the loot is reportedly estimated at £117 million or 55.4 billion naira, but according to the prosecutor, only a portion of that sum may be recovered. In the meantime, another former governor, Edo State of Edo State, is challenging a move by the Economic and Financial Crimes Commission, EFCC, to introduce a new witness in the ongoing 2.2 billion naira fraud trial against him and a firm, Spotless Investment Limited. On February the 17th, the court will rule on whether the witness, Johnson Abidakun, who is the head of operations, Zenith Bank Ado Ekiti branch, if he can testify in the trial. The Economic and Financial Crimes Commission had brought Mr. Abidakun to replace the bullion van driver with Zenith Bank of the same branch, who had earlier testified in the case. The prosecuting counsel, Sir Rotimi Jacobs, had alleged that the testimony given by the bullion van driver was different from the statement he wrote at the EFCC's office during investigation of the case. Mr. Jacobs alleged that Mr. Fayosi had gone behind to compromise the witness by threatening him, but the defense counsel, and that is Olanikpeku and Olalekonjo, they both opposed the prosecution's move, describing it as an abuse of court process. And in Kogi State, it's a former deputy governor in the eye of the legal storm. A high court sitting in Lokoja, the state capital, has fixed ruling for February the 27th on the legality of the removal of Mr. Simon Achuba as deputy governor. Mr. Achuba's counsel, Mr. Jibrin Okutepa, in his submission, asked the court to declare the removal of the former deputy governor by the House of Assembly as a violation of the Constitution. He's also seeking the court's declaration of the lawmakers' actions and subsequent nomination of Chief Edward Onoja for deputy governor as null and void, describing the action of the Assembly as a constitutional coup. Or responding, counsel to the defendants pray the court to dismiss the suit as the claimant has no power to challenge the proceedings of the House of Assembly. Ms. Adeni described the issues raised in the originating summons submitted by the counsel to the former deputy governor as vexatious and centered on guesswork. Of the trial judge, John Olorunfemi, fixed ruling for the 27th of next month after hearing all the submissions of the counsel. Well, let's shift our attention now to politics and governance of Imo State in Nigeria's southeast region, where the new governor, Hope Uzodinma, has kick-started piloting the affairs of the state after officially resuming work after his swearing in. The new governor, on his arrival at Government House in Owerri, held several crucial meetings, including top officials of the Imo State Civil Service and also all the security chiefs in the state. And the governor, we hear, has also made his first appointment. So he has appointed Cosmos Iwu as the secretary to the Imo State government, while Mr. Syrian Akolisa is the new Attorney General and Commissioner for Justice. Others are Barrister Nnamdi Anyihie, who will be the Chief of Staff to the governor, and Ogwike Nwachukwu as the Chief Press Secretary and also Media Advisor. But the People's Democratic Party, they're calling for the immediate review and reversal of the decision of the Supreme Court on the Imo State governorship election. Addressing journalists in Abuja after a meeting of the National Working Committee of the party's national chairman, Mr. Uche Secondus, said that the review would be in the interest of justice. He also explained that the party's National Working Committee had examined all the issues relating to the judgment and alleges that the apex court, as presently constituted, has become heavily compromised. The PDP chairman insists that the panel should recuse itself from the remaining governorship petitions pending before the court.
Our party has it in good authority that Justice Tanko and his panel are working on instruction from certain forces in the presidency to use the Supreme Court to take over states lawfully won by the PDP and award them to APC. The PDP, therefore, advises Justice Tanko not to allow himself to be used to push our nation to the path of anarchy and constitutional crisis, as any further attempt to subvert the justice in the pending petitions in Sokoto, Bauchi, and Benue, Adamawa, as well as Kano and Plateau states, will be firmly and vehemently resisted. The PDP demands that Justice Tanko Mohammed immediately step down as CGN and chairman of the National Judicial Council, as Nigerians have lost confidence in him and a Supreme Court under his leadership. Justice Tanko must not head the panel to determine the remaining election petition before the Supreme Court. We demand that the decision of the Supreme Court on the Imo governorship election be reviewed and reversed in the interest of justice.
Well, the dust following the Supreme Court judgment of Tuesday appears yet to settle. Mixed reactions from the ruling and opposition parties and also non-party members that are taking different opinions on this issue. While the All Progressives Congress is celebrating the victory, the People's Democratic Party are rejecting the decision of the Apex Court. Well, to talk more about some of the concerns raised, joining me in the studio is Mrs. Victoria Ibezim-Ohaeri. She's a legal practitioner and Director of Policy and Research at Spaces for Change. Thank you for joining us today.
Thank you for having me.
All right. What are your thoughts about this? The PDP national chairman saying that the judgment has been compromised and saying that the Chief Justice, head of the panel, should recuse himself.
Yeah, I think that judgment, the most recent judgment of the Supreme Court on Imo gubernatorial elections, is one that has raised a lot of mixed reactions, and surprise, shock, what they would call like a judicial upset, and particularly in electoral jurisprudence. So consistent with the right to free speech guaranteed under the Constitution of Nigeria, I think the party or the chairman of the party has the right to agree or disagree with the outcome of the Supreme Court decision and citing his reasons. And I think that's just what he has done.
Yes, but the thing is, he said that they've examined some of the issues, and they're saying that the panel, as constituted, appears heavily compromised.
Yeah, there's a lot of conversation about, and also drama reported in the media about the constitution of the panel. That's not for me to really talk about. But in terms of the decision itself, it has raised a lot of questions. Questions about evidence, questions about voting patterns, questions about even the arithmetic that emerged after the decision.
Especially having the number 4
yeah,
now.
Yeah, the number of accredited voters and the number of the votes exceeding the number of accredited voters. There are lots of very strong legal questions emerging from that decision. And the party is within their right, the limits of their right to ask those questions. So there are procedures for taking those demands forward, and it's left for the party, I think, their legal team to do what they have to do.
He's also talked about a review of that judgment. I mean, on what grounds can a decision of the Supreme Court be set aside? Yeah,
it's the Supreme Court because it's the highest court of the land. It's the Supreme Court itself that has to undertake that review, and that is what makes it a bit complicated. But there are procedures that the law has laid down, and which I think the party probably may explore. Some of the legal questions that are arising, some of the questions we've already mentioned, some of the things that are worrying, and what we say worrying, because of the Supreme Court is the highest court of the land, and any decision that is made at that level has to go all the way down because of the principle of stare decisis, or that is binding on all lower courts. So if they are concerned, deeply concerned about the impact it might have on future elections and future decisions, this is the time for the judiciary, not just the party, the judiciary and all concerned parties, because a lot of conversation is happening like outside the spaces where those changes can be influenced. So there is need for probably for them to coalesce and take the necessary steps.
Yes, and that's what we don't know, if a formal complaint has already been made, because we have a decision, I believe on Monday, for some of the other states, which some people are a little worried about. I would ask you...
Sokoto?
Yes, and Kano and the rest of them. I was going to ask you if you expect any more surprises, but we also know that in history we had the situation with Justice Bokachoa, and then, members of her panel didn't think that, there was going to be any form of bias, but she, on personal grounds, recused herself. That's during the Court of Appeal, when it got to the Court of Appeal. So in this case, what do you think would happen? This is the Chief Justice, of Nigeria. He's also the head of the National Judicial Council.
Yeah, because that's why I say it's going to be a bit complicated, because it's like between a hard rock and a hard place. The institution you are looking up to make the same changes is exactly the body you are also complaining against. So it's like the jury and the, how's the way they say it? The prosecution and the jury at the same time. And that makes it a bit difficult. But I think it is important for some of these issues to be tested. Why it needs to be tested is because the first is the precedent that is being laid. The second is the implication on the democracy, on our democracy as a whole. Because first and foremost, election petitions they're almost altering the democratic pattern.
Well, finally, we have several other cases. Sokoto, Bauchi, Benue, Adamawa, Kano, and Plateau States pending. Should we expect to see any surprises, do you think?
There may be surprises, but the sad part is that it's too late for anything to happen now, because the parties would have learned from what happened in more elections. Even when we say something is wrong with this judgment, there is also the other side. Because what happened was that the court admitted certain evidence that was omitted at the tribunal and at the Court of Appeal. So the question now is the weight to be attached to evidence that have been admitted already before the court. And it's a discretionary matter, which is only the judges that can make that. So wherever the decisions are, they've probably been written. The surprises are already there. But if had there been that this decision came much longer before now, probably the other the lawyers or the legal teams would have had opportunity to appraise the pleadings, processes, and evidence that they've tendered before the court. So I can see whether they can make some necessary changes.
All right. We'd like to appreciate you for coming on today. Thank you.
Thank you for having me.
Well, Nigeria's main opposition party, the People's Democratic Party now, they're holding their first National Executive Committee meeting in Abuja at the party's national headquarters. At the meeting, the candidate of the PDP at the 2019 presidential election, Mr. Abubakar Atiku, is asking the party's NEC to set up a special committee that will review the 2019 general election and re-strategize for future elections. The NEC emergency meeting is coming after the loss of the Imo State by the party to the All Progressives Congress, whose candidate, Senator Hope Uzodinma, took over from Mr. Emeka Ihedioha on Wednesday as governor of that state. The federal government is hoping to pass the Petroleum Industry Bill before May 29, 2020. Details of that move now have been explained by the Minister of State for Petroleum Resources, Mr. Timipre Silva, at a news conference in Abuja. He says a team is already concluding the harmonization of the various versions of the bill. According to him, the bill will be passed as a single document and not broken down into different components, as was done under the 8th National Assembly. However, the bill will be divided into two parts: the Petroleum Industry Fiscal Bill and the Petroleum Industry Governance Administration and Host Communities Bill.
Counting on the current harmony between the executive and the legislative arms of government, we are optimistic that both the Petroleum Industry Governance Administration and Host Communities Bill, on the one hand, and the Petroleum Industry Fiscal Bill, on the other hand, will be passed within the first anniversary of this administration. The PIB is one bill. I only looked at the two parts of the bill. So when we approach the bill, we are not taking it as a bill in parts. We are going to take it as a bulk bill. It will be passed as a PIB. But of course, in the PIB, you have the Petroleum Industry Governance Administration and Host Communities Bill and the Petroleum Industry Fiscal Bill. These are two parts of the same bill governing the same sector. So we're going to take it as one.
Elsewhere, the director in charge of operations at the Niger Delta Development Commission, NDDC, Dr. Cairo Jugbo, says there have been huge corruption, and if not for President Buhari, the NDDC would be dead. Dr. Jugbo opened a can of worms on the state of affairs of the commission when he addressed a press conference in Port Harcourt, saying that there has been over ₦1 trillion lost to fraudulent projects in just 3 years at the NDDC.
Without President Muhammadu Buhari, NDDC would have been killed and buried. In 7 months in 2019, a total of 1,921 emergency contracts valued at 349,631,757 naira 70 kobo was awarded, while the unprocessed budget of the NDDC was barely 350 billion for that year. That is 3 times what the normal budget of the NDDC would have been. So with this volume of exposure, you now see why the president had to order for this forensic audit. You now see the reason why the Interim Management Committee has set up this verification exercise.